sent to your email this morning.
Good afternoon, members of Parliament, support staff, radio listeners, TV viewers, those following via Parliament's social media platforms, and members of the media. Welcome to the Central Committee meeting number 18 of today, Monday, June 12, 2023. We have established a quorum of 8 members. Please stand for a moment of silence. Thank you. I have received notice of absence from the following member, MP Sarah Westcott-Williams. Are there any other notifications? MP Grisha Halliger-Martin, you have the floor.
A pleasant good afternoon to you, Mr. Chair. Good afternoon to my fellow colleagues. Good afternoon to those listening and viewing online on the radio. And online. I covered everything. Mr. Chairman, I've taken note of the convocations this week. I'm also looking at the time that we have at least 3 more weeks until recess. And my concern is of some meetings that we still have pending and open, and I hope that you're taking these into consideration. I have still a meeting for 7 months now pending. Tele-meeting, 7 months. We've never called that meeting. Are we going to be able to at least have that meeting called before recess? Recess is a whole entire month, a month and a half, like July 1st to the mid-August, 6 weeks. Can we at least call the tele-meeting before recess? We also have some meetings open, which is the reconstruction of the airport. We'd like to know if it's possible to close that meeting off. That has been pending for 7 months as well. And I have a meeting pending for 5 months that's been also pending, which is the prison meeting. And these are all, for the most, public. These were urgent meetings. And an urgent meeting that had to be called in 4 days, still open for 7 months. So I would like to please bring your attention, draw your attention to these, and hopefully that you can maybe have them on the convocations between now and before recess. Thank you, Mr. Chairman.
Thank you, MP Grisha Halliger-Martin. I see MP Rolando Bryson, but before going to that, I would answer MP Grisha Halliger-Martin that most of these meetings are on the schedule. Hopefully in the next 2 weeks or 3 weeks, they will be, and most likely we are trying to get it off before the recess. MP Bryson, you have the floor.
Thank you, Mr. Chairman. Good afternoon to yourself, the Secretary General, my colleague members of Parliament, and those viewing. Mr. Chairman, indeed, as you know, I wanted to kind of elaborate on that aspect as well, because this was something that we did discuss in the Presidium in terms of outstanding meetings. And as you know, when, let's say, this Presidium went in, one of the things we decided was we would collectively as a Presidium ensure that we try as much as possible to deal with the meetings that were outstanding. Particularly when it comes to ministers, meetings where the minister's presence was requested. At the time, from October 27th, there were 26 meetings in which the minister's presence were requested. Up until when we had that meeting, that was, I believe, a week ago, we have 15 meetings with ministers pending. So I think we have to continue to try as much as possible to get that backlog cleared. I do know that especially within some of the committees, that is something that we have discussed, that with the committee chairs, especially in those where the minister's presence is requested, that we try to prioritize also getting those committee meetings out of the way. I think it's also important, the public meetings. But the committee meetings, as we've seen right now, as a result of activities of the committee, it can lead to a lot of fruitful things coming out of the committees, especially the committee of ECUIS, where we know it's the committee that gets the most requests. So naturally, it's no surprise that there's also quite some meetings there. So I do hope that we can try to get as many of those out before the end of the recess and continue what we're doing, which is getting as much as the backlog that we met, getting them out of the way. Thank you, Mr. Chairman.
Thank you, MP Bryson. No more notifications. We go over to the agenda point. Agenda point 1, report submitted by Committee of Justice regarding draft criminal procedure code. Agenda point 2 is approval of travel schedule for the second semester of the year 2023 in connection with committee, Assamblea, Board of Directors, that is Junta Directiva, and Eurolat meetings of Parlatino under the document IS/771/2022-23, dated May 26, 2023. We go over to the agenda point 1. Report submitted by Committee of Justice regarding draft criminal procedure code. On June 8, 2023, the Committee of Justice of Parliament requested Parliament to forward the report regarding the draft criminal procedure code to the Minister of Justice for further handling. The report includes an analysis of the draft criminal procedure code conducted for the committee. This document is registered under IS/836/2022-23. The request therefore is for the Central Committee to honor the request of the Justice Committee. I would like to ask the Chairman of the committee, MP Bryson, to elaborate on this request. MP Bryson, you have the floor.
Thank you, Mr. Chairman, and good afternoon once again. Mr. Chairman, first of all, I would like to thank all of the members of the Justice Committee for the many debates that we've had. I think most of them behind closed doors, considering the ability for members of Parliament to discuss freely, and members of the committee, together with the legal support that was hired, to discuss what we believe the proposed criminal procedure code should entail, what our opinions are in terms of what we should include, what we could exclude, and very importantly, ensuring that whatever we do is in line with the requirements of the Financial Action Task Force. Mr. Chairman, just to summarize a little bit, so for those viewing and a bit of a recap, on 19th of June 2019, the Parliament received the draft of a new criminal procedure code. As a member of Parliament at that time, I remember when you would read, let's say, the title of the law, and when you look at the presentation of the law was presented to Parliament under the premise of, we are doing this in order to get in line with Financial Action Task Force. However, in that Central Committee meeting, I remember discussing with various members, it was both the coalition and opposition, that were having this discussion, because I pointed out the fact that many of the articles that were being included or proposed in that law had really nothing to do with FATF requirements. So that raised a bit of a confusion as to, well, what is the purpose of this law actually? Is it just about creating a new criminal procedure code, which is good? I mean, if we're going to update the procedures so that the balance in the justice system remains intact, that is good. But many of us found it strange that the purpose of the law was FATF, but we saw things in there that were very far removed from any requirements of the FATF. Between that time, there were various debates, like I mentioned, and then in March 20th of 2020, we had the public meeting of handling of this. In that meeting, various members of Parliament, I believe MP Westcott Williams, myself, MP Bonkamper, even using our amendment right to try to see how we can make such an adjustment, we realized the Criminal Procedure Code is such a heavily technical document. It is something very difficult for members of Parliament individually to be able to amend. So while our amendments, if you look at them, we're going in the direction of what we might envision as Parliament for a fairer Criminal Procedure Code, the technicality behind being able to draft such amendments and ensure that, well, you don't want to just pass something in Parliament and then it's not technically correct, and then it goes to the governor and it doesn't get ratified, that the amendment effort of the members of Parliament would have gone for naught. It was decided then that, you know what, let us make use of the Committee of Justice, by means of then hiring a law firm to actually come in and assist us with this. Let us present these findings that we've had, that we brought out within the Central Committee, and then in the public meeting, the amendments that members of Parliament had presented, and let's handle it in that setting. That has since been done. It's been quite some time, but we have to consider, of course, we were dealing with the pandemic. It was at one point, the document that we received were over 600 pages, I believe. So it was quite a lot of work that went into it. And with that, I also need to thank the law firm and specifically Ms. Peggy Ann Brandon, who I think did an excellent job interacting with the members of Parliament, preparing these proposed changes that the Committee of Justice is now presenting to the Central Committee. Mr. Chairman, if I can just maybe highlight a few of the things, some of the things that we kind of, within this report from the February 20th, 2023 from the Justice Committee of Parliament. Some of the key things that we looked at is, first of all, the concordance and uniformity. We always keep hearing that our justice system needs to have uniformity and concordance within the kingdom. But in the analysis that was done by the law firm, we found that actually what was being proposed, a lot of the things are much more stringent or less stringent than is done in other parts of the kingdom. And that goes against the principle of concordance. So there are various changes in here that seek to actually bring us in line with even the Netherlands. And I would think that this should not have any objection from, let's say, any of the other parties, the governor, the judicial branch, and so on, because concordance is a central principle of our legal system. So some of those adjustments are made. There's also some addressing possible discriminatory treatment. Formulations provided are discriminatory in nature and once again sent St. Martin in a derogatory position towards the Netherlands. Distinctive treatment of St. Martin members of Parliament and ministers is such an example. With legislation already in place, not applicable anywhere in the kingdom, the Parliament of St. Martin cannot reconcile the proposed text to further enhance the distinction between its political figures and those in the Netherlands. The formulation is discriminatory and unacceptable while lacking a supportive legal basis to further enhance this disparity. So what the law firm is highlighting here is that when they took the Criminal Procedure Code of the Netherlands and take our collective Criminal Procedure Code of the countries, we see a very clear, I mean, maybe some might say the word discriminatory is a rough word, but I think she's using that in the legal context, so not discriminatory in our own, let's say, English context. From a legal perspective, it can be seen as discriminatory. The proposals that were made are not in line with actual circumstances. That was one of the things that was found. Many formulations are pegged to the penal procedure codes in the Netherlands, yet proper customizations is not adhered to ensure that the proposed procedure fits within the local environment. So for example, one of the things in the original law was that they would now allow the hacking of computers as an investigative tool. And in the toelichting of the law, when you read it, it says, yeah, you know, this is something that is done in the Netherlands. But what was failed to be taken into context is that the Netherlands also has a computer wet that based on the computer law is how you have the framework for where you should be hacked, when not, your data protection, etc. So it's like certain aspects of the Netherlands were going to be included in the Criminal Procedure Code without the proper context for, yes, it is in the Criminal Procedure Code of the Netherlands, but that article on the hacking of computers is tied to the computer wet of the Netherlands, which we do not have. So those formulations are also introduced. The definition of doorzoeken, which is related to house searches, had to be enhanced. So those proposals are made in here as well, because a set guidelines based on how far does a doorzoeken go, if it's within the premises, is it outside the premises, is it, if you find evidence there, does it lead automatically to a house search in another location, those type of things. One of the more controversial aspects in this legislation was Article 261 EV, where the formulation, and this has to do with the introduction of a crown witness within our legal system. This really jumped out at me in 2019. It was very interesting, the timing of all of this as what was happening, where in our legal system, the explanation is being given that based on jurisprudence in the Netherlands, we can make use of crown witnesses. And yet when they codified it in the new Article 261 of the Criminal Procedure Code, you saw a very big difference between how a crown witness is handled in the Netherlands versus what was being proposed in our law. One of the key things is sorry, I lost it there. Yes, it was not in line with the international standards of treatment of crown witnesses, and it did not sufficiently restrict offers that can be made. That aspect of offers being made is a very important international principle, because you do not want to create a legal system where basically what your legal system does is basically just constantly buy witnesses. There needs to be very clear guidelines as to when a sort of deal is made with a witness that's actually a suspect as well. And the 261 that was formulated before, in the opinion of the law firm and what was handled in the Justice Committee, that whole situation of how we were going to go about a crown witness was not well received and has been adjusted. The ability for provision for a multiple chamber in first instance for complex cases related to financial crimes, crimes of terrorism, criminal organization, and murder. As you know, generally in first instance, the defendant is faced by one judge. However, in the opinion of the law firm, and also looking at the recommendations, particularly in handling crimes of terrorism and money laundering and criminal organizations, which is what the FATF looks to address, having a multiple chamber, so more than one judge, is especially important to allow the judgment to be as clear in first instance as possible. So not that, okay, well, that was only one judge, so I'm appealing the case, when then you go to 3 judges. But in complex crimes like this, the recommendation was that the option for multiple chambers to be introduced even in first instance, and the criteria for that is also elucidated upon. There's also an introduction of damage compensation articles which exist in the Netherlands and globally, where to be enhanced so that third parties not being subjects of criminal investigation too can receive compensation for sustained damages. Provisions for declaratory statements or instruction of order to remove online articles, publications as a possible form of restitution on the request of the defendant is also included. We have seen many situations in our country where people have been made suspects for years and years and years, ultimately acquitted, and then there is no sort of restitution that is offered to them for the public damage that is done. With this article, there's an introduction of these sort of options for restitution, where a defendant or a former suspect can file to request, for example, press releases that came out to be recanted, to make sure that you get a statement in writing from the prosecution that you've been removed, et cetera, et cetera. So those aspects are also added. So there basically 13 main topics or articles, well, not articles, but 13 main issues that have been addressed in what the Justice Committee is proposing to be sent on to the government. I think that the route would then be that the Central Committee, if the members of Parliament and my colleagues agree to have this sent forward to the Minister of Justice, my suggestion would be, is we also request within a certain time frame a response in terms of what the government would plan to do with this. Because what we have here is actually a full legislation. So it is a draft amending the Criminal Procedure Code, rather than what was going to be done, which was drafting an entire Criminal Procedure Code. This would then say that the existing Criminal Procedure Code can be amended as being proposed by the Justice Committee, and then that could make its round to Parliament, or the Parliament would have to see what other options by initiative, or I think that would probably be less practical, in my opinion, for Parliament to initiate this. I do think this needs to go through the vetting process of the government, so that both the judicial branch as well as the government, the civil service, can also go through what we're proposing here. And then if they agreed, Council of Ministers, Council of Advice, Parliament, etc. So once again, thanks to all who have contributed significantly to this discussion, and I hope that the Central Committee can approve this so that the Minister of Justice can get to work. Also, in the context, what I forgot to mention is that considering that there is going to be another round of mutual evaluations from the Financial Action Task Force coming up in 2024, at least the minister having this documentation will also assist in the mutual evaluation, because it will show that the process didn't just stop. We didn't just not handle the Criminal Procedure Code. We didn't just vote against it. What we did is we did due diligence, we have results, and this can also be presented to the FATF if the government so wishes. Thank you, Mr. Chairman.
Thank you, MP Bryson, for giving out the timeline and the update. But just a quick remark, what is the suggested time frame you're looking into this? Any, to take a note here,
Perhaps what we could say is we're going to have recess in the month of July. Maybe we can ask that they send it by the time the recess is over. That's what, like 8 weeks or something like that? Because we wouldn't be handling it during the recess anyway. So perhaps that might be a way to do it, that by the first week after the recess, if the response can be sent.
Thank you, MP Bryson. Now I would like to move to the members of parliament if there's any other remarks or questions, and I see MP Melissa Gums. MP Gums, you have the floor.
Thank you, Mr. Chairman, and good afternoon to you, my colleagues, and those joining us. This is not so much a question as just a comment in terms of the timeline. I think that I agree with the suggestion of recess being the period, but if the Minister of Justice could kind of update her own timeline, because according to me, the evaluations usually occur in November. So just that we can keep that in mind as well when requesting her insight into the document. Thank you.
Thank you, MP Gums. Any other member of parliament has any remarks or questions? I don't see. MP George Pantaplet. MP George, you have the floor.
Thank you, Mr. Chairman, and good afternoon to the chair, my colleagues of the Senate Committee, and of course those of the Justice Committee. Mr. Chairman, I just want to thank the Member of Parliament, Randall Bryson, for his very in-depth explanation and giving us a historical perspective as to what transpired. I just want to remark, because I believe that that one thing was mentioned is how soon that the Minister of Justice would get back to us. I think that was mentioned. And let me add on the Minister's behalf that she has been clamoring for quite a while to get it from Parliament as soon as possible in order for her to proceed with it. But I think it's important what Parliament has done, what the committee has done in taking time and going through and making sure, because these are very, very serious changes, Mr. Chairman, and I believe that we have to make sure that once it reached to the point where it has been approved and so on, that we would not return and say, well, why had we not done this, had we not done that? So I believe that due diligence was done, and I believe that when the time comes for us to, of course, after the minister have gone through it and come back to Parliament, that will make sure that, and hopefully that nothing else will come to the forefront again, because, again, when it comes to the justice system, I've always said this, even in the days of the Island Council, that I don't trust the manner in which the Dutch are doing things, because they always have ulterior motives. And if we don't take our time and go through it carefully, we'll find ourselves, let me use a very strong word, signing our death sentence. Thank you, Mr. Chairman.
Thank you, MP George Pantaplet. The next person, again, I see MP Rolando Bryson. MP Bryson, you have the floor.
Thank you, Mr. Chairman. I agree on both of those points. I think, yes, it's true. We should take into consideration the timeline of the mutual evaluation to ensure that our minister is prepared. We want to prevent a situation that happened before where St. Martin was gray listed. But I believe that part of the gray listing happened when we would say we're going to do something and then it wasn't done. So if the government tells the FATF, which I think was something that the government should not have done, because the government was basically kind of sitting on the seat of Parliament and saying that, oh, we're going to make sure Parliament passes it by, this date. And that was what we were being presented as parliamentarians. When the debate had started, it kind of felt like we had to treat this as a hammerstuck, as, we got to get it done. And then you were told, yeah, and then your ATM machines ain't going to work, and all of this stuff was being said. and don't pass it and you're going to see, and all kinds of stuff were being told when we were just really, honestly, sounding the alarm on certain issues. And the way it was being pushed, I've never seen legislation since I've been a member of parliament insisted upon so heavily by a government. But I've also, to the credit of being an opposition member at the time and having members of the coalition like Theo Heiliger, Franklin Myers especially, who were willing to listen to us and say, guys, did you really read within this 600-page document? There's little things that I call that were slipped in. That there was no part of the presentation that was given by the government. There was no mention, for example, in the presentation of Crown Witness and hacking, for example, but it was in the law. And that's where I agree. The due diligence of members of parliament to be able to go into this. And now the Justice Committee having completed this process was, I think, a very good milestone for the Parliament of St. Martin. We are the legislators. The government can bring legislation to Parliament all they want, but we have to take decisions on whether we think this is good for the country or not. And I think the approach that we've taken for this over these years is an example for how we should handle especially complex legislation like this before us. And not that just because someone says, oh, we're going to get cut off from the financial system and so on. When you read the actual reports, what they kept saying is that, yeah, but last year when you came, you said that the parliament was going to pass it. This time when the minister came, her approach or went to the FATF, when you look at the reports, there's no mention of, yeah, I'm going to make sure the parliament pass it, to use general terms. It was, the parliament is currently doing a review of the Criminal Procedure Code. The parliament believes that they would be able to make some changes that bring it in line with FATF. On the point of the minister writing to the Committee of Justice and saying, you know, that there's some urgency here, I agree. That urgency exists, but now the urgency will be back in her court. So I do think that the deadline that we're proposing to have it handled after the recess is a good one. I think also maybe we should add this within what is sent to the government, is that they give it to the judicial branch. I personally would be very curious to hear. The last time the Criminal Procedure Code was sent to the judicial branches, we got responses from it. And a lot of it was positive. A lot of it was, oh, we need this, we need this. I would be interesting to see what the judicial branch now thinks about the proposals that were not just drawn up by members of parliament, but drawn up by a very reputable law firm within our country with vast experience in criminal law, seeing both sides of the equation. There's a reason why the emblem of justice has a balance on it. It's not like this, it's not like this. We do not aim within this draft, I believe, to bring anything in favor of the defendant or in the favor of the prosecution. I believe what we're doing with this draft is bringing it back into balance. Having people there's something here, a simple thing, like language. The Constitution is being constantly ignored within the courthouse right across from us that says that English and Dutch are our official languages. And you have people that, most of our population don't speak Dutch. And it's like almost a nuisance to you to be able to have to hear something via a translator and so on. So these guidelines are being put in proper context where, for example, someone can choose to get their own translator paid for and provided for by the government. Those type of things are very important to keep the balance and fairness within our judicial system. The last thing I want to say is that, you know, within all, you know, MP George mentioned about, you know, the Dutch government and whether they want to see an even playing field. And that is why I stress again, the fact that the concordance principle within these changes are very much at the forefront. I would find it interesting to see why anyone would tell us what is allowed in Holland is not allowed here. The rights that a civilian within the European Netherlands has within the court system there is not good enough for our local people. That's why I do think, let us hear and ask the minister to hear from the judicial branch what they believe in terms of this amendment to the Criminal Procedure Code. Thank you, Mr. Chairman.
Thank you, MP Bryson. I see MP Grisha Halliger Martin. MP, you have the floor.
Thank you, Mr. Chairman. Mr. Chairman, in February 2020, when we just swore in, the first thing that we had to deal with was the CFATF law. And I remember it being nerve-wracking, seeing the laws that was in front of us and the imbalance of the laws, and what we've accomplished so far within this committee and where we are now sending this document over. I feel like for once I could finally say we did something, and we're finally bringing the justice system into balance with these suggestions. So I really do look forward to getting the feedback from the the Minister of Justice, as well as what MP Bryson also suggested, getting from the judicial branch also their feedback. So I'm really looking forward to that, but I feel very confident with what we have presented here thus far, and I'm very happy to see that we've accomplished something that I campaigned on from day one, bringing balance to the justice system. So looking forward to that, Mr. Chairman.
Thank you, MP Grisha Halliger Martin. I don't see no further comments. So if there are no further comments, the document will be forwarded to the Minister of Justice for further handling with the suggested time frame and the request for an update from the Minister on her timeline. We go over to the agenda point. Also, to have it reviewed by the others in the justice system. We go over to the agenda point 2, approval of travel schedule for the second semester of the year 2023 in connection with the committee and board of directors Junta Directiva meetings of Parlatino. Under IS document 771/2022-23, dated May 26, 2023. On May 26, 2023, Parliament received the schedule of the second semester of Parlatino meetings that are scheduled for the second half of 2023, that is from June to December 2023. This schedule includes various committee meetings and board of directors meeting. This document is registered as incoming document under IS 771/22-23, dated May 26, 2023. All members of Parliament received a copy of this document via email, and it can also be found on the P drive of the Parliament. It is good to note that the schedule is a draft and is therefore subject to changes. It is customary that the delegation comprises of 2 persons per committee to attend these meetings. It is also customary that the chairperson of Parliament, accompanied by the Secretary General of Parliament, attend the General Assembly, Board of Directors, and Eurolat meetings of Parlatino. The proposal to Parliament is to approve the work visits for the members of Parliament, the Chairperson of Parliament, and the Secretary General of Parliament to attend the meetings as per this draft schedule for the second semester of the year 2023 in connection with the Committee, General Assembly, Assamblea, Board of Directors, that is Junta Directiva, meetings of Parlatino and Eurolat meetings, and any other amendments, updates that might be presented by Parlatino to this draft schedule for the second semester of the year 2023. The proposal is furthermore to approve the travel arrangements for the delegations as per the travel guidelines of Parliament. Any member of Parliament for any discussions, any points, any comments? No. Thank you, members of Parliament. If there are no comments, these work visits are approved and we will proceed accordingly. Ladies and gentlemen, we have come to the end of this meeting. I thank you all for your participation and I hereby close this meeting.